Welcome to Education in Focus. I'm your host, Aliana Kernodle. This week, the American Civil Liberties Union of Texas sent a letter to over 50 school districts in the state, claiming their dress codes are in violation of a state law aimed at protecting students from hair discrimination. Joining me to dig into this is Chalkboard News editor Brendan Clary. Brendan, what is the state law and what concerns are the ACLU raising?
Yeah, that's a great question. So the law is called the Texas Crown Act, and that's an acronym for Creating a Respectful and Open World for Natural Hair. And so that was signed into law last year. And so basically that added protections in the state's anti-discrimination law to protect historic hairstyles that are associated with race, right? So specific kinds of, traditional hairstyles for Black individuals, that those would be kind of added into this anti-discrimination law. So you couldn't be fired from your job because you wanted to wear your hair, with commonly or historically associated with race, like, afros or cornrows or braids or locks. So essentially like these different kinds of hair styles that have, historical and like cultural significance, right? So the ACLU is very concerned about kind of making sure that these school districts are not violating that law. And they are challenging these school districts who they say have potentially open to interpretation policies or that maybe violate the law, right? So they're sending these letters to districts where they're saying, hey, like we've looked at your policies. We don't think that they have, enough protection based on the law for students of color who maybe want to wear these kinds of natural hair textures or these hairstyles. So you need to update your policy, ahead of the 2024-2025 school year, right? You need to get in and do this and make sure that you're not going to violate the law. So I think that's the ACLU's big concern there, is that students should, like under the law, are protected and that they have the ability to wear their hair the way that they want to. So I think that's sort of the ACLU's concern. That's what they said in their letters, right? They basically reached out and just said, hey, like this is the law. This took effect September 1st last year and basically prohibits racial discrimination based on students' hair texture or protective hairstyles. So, and basically the law states, this is what the ACLU is saying to these districts, that the dress or grooming policy adopted by a school district, including a student dress or grooming policy for any extracurricular activity, may not discriminate against a hair texture or protective hairstyle commonly or historically associated with race. So that is from the law. And then it defines kind of what those hairstyles would be, like braids, locks, and twists. So it's an interesting sort of thing, but basically just reaching out and saying to school districts, you need to be thinking about this based on what the law says.
And there's a recent court case about this law dealing with a district's dress code policy. How does that kind of tie into this story? Yeah,
that's a great question. So basically, the Crown Act, prohibits discrimination based on hair textures, hair types, and protective hairstyles associated with race. And so the ACLU pointed out in their recent letters, like, hey, like these school dress and grooming provisions that ban those, or maybe don't even include things like that are about racial or cultural hairstyles, but things like, the more subjective terms like natural or well-groomed or distracting or extreme, these kinds of like subjective terminology for different kinds of hairstyles, that might violate the law. Basically, if you have those in your policy where it's sort of like subjective there. But what's not subjective are, some of and what the court found in that recent ruling that you were mentioning, that we covered at Chalkboard News as well, our freelancer, Julian Roberts-Gramella. There was a student who sued over at his district, I think it was Barbers Hill Independent Schools District, that this student, Daryl George, sued them and said that, the school district's policy about hair length violates the Crown Act because I'm not allowed to wear my hair as long, like it's a braided hairstyle. But, the school district is saying this violates their policy. And he received like a suspension, right? He was out of school and was suing the school district over this policy. And he said, this violates my rights. And the court said, no, it doesn't. Like the schools can have policies about hair length, that is not, it's not arbitrary, like, trendy or distracting or extreme. And, and the Barbers Hill Independent School District had a policy about, I think, like eyebrow length, hair, or, different kinds of like that here's our grooming policy. This is what we expect our students to do. And the judge said in that case that is fine, that is protected under the law, that, you can have that. And the school interpreted it that way of like, like there's not complete freedom from this law. Like you can have, the hairstyle that you want, and that there are these protected things, but it's not like a racial, thing to say like, this is what our policy is going to be. And it's not discriminatory. Like we're going to have this set. So, and that was the interesting thing in that the court case found that there is protections there, but not like complete freedom, right? Students don't have the right to just wear whatever kind of hair they want to. If it's a historic or like a protected hairstyle, you don't have like complete and absolute freedom. And I think that might be like some of the case there. And Daryl George, his lawyer said that they're going to try to file. I haven't seen anything about that. And I did look, I haven't seen any real updates there about like taking this to the next step or trying to go up to another court. So I may have missed something, but I haven't seen anything like that recently.
Well, this is a very interesting story, just kind of trying to thread that needle between having limits on just dress code policy in general, but also making sure that those limits aren't discriminatory. And it sounds like this is sort of an ongoing process. You mentioned this law, it went into effect last September. It's still less than a year old. And they're still probably working that out and figuring out what that looks like. And I'm sure we will follow any further developments on this story, and listeners can keep up with this story and more at chalkboardnews.com.